This is Mid-Atlantic Women in Agriculture's Wednesday webinar, Estate Planning. Our presenter today is Ashley Newhall, Legal Specialist with the Department of Agricultural and Resource Economics. All of our upcoming webinars, along with all archived webinars, can be found at our website. And a special thank you to our sponsors, Mid-Atlantic Farm Credit and PNC. Thank you for listening.
All right, so I'll be talking about estate planning and an important recent development lately. This is an overview, so as a disclaimer, it's intended to provide general information. It's not intended to provide legal advice. So if you have specific issues or situations, please do consult an attorney. And also, our website that you can read up-to-date posts on current ag law issues, UMA, it's aglaw.org. You can visit that. Keep that in mind for all sorts of issues. All right, so back to estate planning. A good initial source when starting to develop these plans is Neil Harl's Farm Estate and Business Planning book. It's in its 17th edition, so that's also something good. A good resource. And since I can't see hands, this will just be a rhetorical question. How many of you have estate plans? Going from there. So a survey shows the U.S. farm population is in line with the rest of the U.S. population as far as estate plans go, which means majority of everyone does not have them. So failing to plan for death can lead to issues when you have assets and land and an entire business and you want it to go to someone specific, whether that be your family or other people, and who gets what. So it's important that these are in place. Benjamin Franklin, among many others, has said, "In this world, nothing can be said to be certain except for death and taxes." And why do I bring this up? Well, because death, unfortunately, is certain, and we do need to prepare for that. So estate planning is considered to be the process of arranging for an orderly transfer of your assets upon your death. An estate plan isn't necessarily one single document, but can include multiple documents that effectively transfer your property at death and achieve other goals. So an estate plan can include, one or many of the following. It could be a will, trust, life insurance policies, a living will, durable power of attorney, healthcare proxy, and I'll be going over all of those. It's important to remember that your estate plan is going to be different than your neighbor's. It's going to be extremely personalized, and it's not going to be a one-size-fits-all. So it's not going to be an extra value meal at a fast food joint. It's going to be, a burger cooked to your liking with your specific ingredients on there that fit your needs and your wants. So why should you think about estate planning? Well, we've already come up with a few ideas, but estate planning allows you to achieve your goals in the transfer of assets to certain family and friends after your death and puts the proper people in charge of your affairs if you become incapacitated. You want to ensure you get the medical treatment you want, and that's important to think about before that happens. You don't want to have to rely on state laws because they may not properly take care of what you want and who you want your assets to transfer to. So a will is a written document that provides instructions on how you want your property and resources to be transferred upon your death. A trust is a legal agreement between you, the grantor, and a manager of the trust, the trustee, for the benefit of a third party, the beneficiary. A durable power of attorney is a legal document that gives one person, the agent, the right to act on behalf of another person, the principal. This is done to allow for your business and financial matters to be continued if you're incapacitated. A healthcare proxy, it gives a third party, the agent, the right to make medical decisions for you if you become incapacitated. A living will is similar to a medical power of attorney. A living will spells out the types of life-saving treatments you desire in a limited number of situations and designates one third party to make those decisions on your behalf when that occurs. So, dying without an estate plan. Without at least a valid will, you would be considered to have died intestate, and state laws will govern how your property is distributed. So, when that happens, like I said previously, your estate may not go to those people that you had previously wanted. Typically, state laws provide that they go to, your direct heirs. Well, if you haven't talked to maybe your son or daughter or someone that's close to you in several years, you may not want that to happen. So the idea is if you wanted your property to go to a specific non-family member, then you should have a written will. That's another reason why it's important to think about these things. So more specifically into wills, as defined earlier, a will is simply the instructions you have on how to distribute your property upon your death. Wills can also provide for other items on how to, and then just distributing your property. So for parents with minor children, you might have something in a will that appoints a guardian to raise your minor children if you were to suddenly pass away. It also appoints an executor or personal representative to make sure the property is distributed according to the terms of your will, among many other things. So will terminology. A testator is the person making the will, so maybe it's you yourself. An executor or personal representative is the person appointed in the will by the testator to administer or carry out the terms of the will. Descendants are the testator's relatives, spouse, children, grandkids, parents, people of that nature. And probate is basically the system in which a court establishes the validity of a will. This allows the personal representative or person in charge of carrying out the will to make distribution of your property and assets after the court has established probate. So now, who can make a will? As one state Supreme Court has pointed out, let it first be stated that one does not have to be a genius, a college graduate, or a high school graduate, or even attended grade school to make a will. So what does that mean? Any person of sound mind over the age of 18 can make a will. A will is only one estate planning tool everyone should consider having. So elements of a valid will: legal age, sound mind, the intent to actually transfer the property. It must be written, properly signed, properly witnessed, and properly executed. So I'm going to go through these one by one. Legal age, as I said before, a person must be at least 18 years of age. And the law typically does not provide an age cutoff for making a will. So you could be 99 years old or 86, just as long as you're over the age of 18. Sound mind. So there are some elements spelled out by courts that determine whether the testator is of sound mind. You must know that you are making a will, the property that you have, and who your descendants are that you will leave your property to. So these elements are set out. You must be able to retain in their memory without prompting the condition and extent of their property, so no one should be able to remind the testator what it is that they're giving away or what their property consists of. The testator must understand who he or she is giving the property to, and they also must realize he or she may be excluding descendants from the will, and this is really important because if they don't realize, it can be said, later in probate that so-and-so was taken out of the will against the testator's intentions. So they must know that maybe they're excluding their third child or, maybe their brother or sister from receiving some sort of property. It's very important. So even if the testator is a little odd or peculiar, they might not, seem to a normal person of sound mind, the court will generally find the testator to be of sound mind if they meet those three requirements. They must have the intention to transfer the property. So your will needs to have clear language that you're intending to give the property away. So language such as I bequeath or upon my death I give. Those are the sort of the language that needs to be apparent in the will. Another really important fact of a will, the will needs to be written. So an oral will is not provided for under Maryland law, so an oral will not be valid. The reason for requiring the will to be in writing is to show everyone the testator's intent of how the testator wanted their property to be transferred at their death, and not allow someone to either, insert language that I heard so-and-so say this once, or we can't remember exactly what the testator said. Did he say Jim or Jen? Things of that nature. That's why it's very important to be in writing. Let's see. An exception to the properly witnessed requirement is a holographic will. So holographic wills are wills that are entirely written in the testator's handwriting and then signed at the end by the testator, as seen as in the picture I posted next to the writing here. So the only valid it's only valid in Maryland if it was made by a member of the armed services and signed by the testator outside of the United States. And it is voided 1 year after discharge. So generally speaking, these holographic wills aren't going to be valid unless you fit that very specific exception. And changing the will, so say, something comes up in your life, such as marriage, divorce, the birth of a child, you move to another state, you acquire new property, you might want to change your will. A will can be changed or amended by drafting a codicil that amends the earlier will, or the person can draft a new will entirely. The codicil or document amending the prior will need to meet all the requirements of a valid will to be valid. Property outside the will that cannot be included in your will are life insurance policies. You have selected the beneficiary of the policy on your death already, so it won't be included. Payable on death bank accounts, the same sort of situation. There's already someone that's been selected that will take over once you do pass. Joint bank accounts, such as joint checking or savings accounts used by a married couple. Remaining account holders would receive the accounts, so you don't have to provide that in your will. Real property held as joint tenants with multiple owners. So traditionally, all property owned by a husband and a wife is owned as joint tenants, and the property would go to surviving owners already. So moving on to trusts. Unlike wills, trust as an estate planning tool isn't for everyone. People who should consider using a trust are those with estates approaching federal estate tax limits for 2014, that is estates over $5.34 million. Those with children or disabled family members to provide for their care if the parents were to unexpectedly pass, and family members that can no longer manage their own affairs, such as elderly parents. Some trust terminology that you might want to know. So the grantor, truster, or settler are various ways to describe the person who creates the trust. The trustee is the person that manages the property in the trust, and the beneficiary is the third party that actually benefits from the trust. Types of trusts include a testamentary trust. This trust is created in a will upon the death of the grantor. It's typically used to provide for the benefit of minor children or disabled family members. A living trust is created during the testator or the trustor's life and continues after the trustor's death. It's used by many people as a way to avoid the probate process upon their death. It can either be revocable or irrevocable. A revocable living trust, you retain control of the trust to change the beneficiaries, the trustee, the terms, and you can even choose to dissolve the trust at any point in time. So basically you retain all control. An irrevocable trust, it's permanent and you retain no power to change the trust. So a living trust, reasons to consider a living trust. To avoid probate costs. It allows for the transfer of property in different states. It allows for managing of assets if you become incapacitated, and it distributes property to the beneficiaries faster than if you went through the probate process, which is when you use a will. Reasons to not consider a living trust. Expensive to set up and update, requires a lawyer to draft a trust documents and to administer. So here the expenses can outweigh the benefits. So this is another reason why it's not maybe for everyone. All right, and Another tool in estate planning is the durable power of attorney. Appoints an attorney in fact or agent to handle your business and financial issues that could arise if you become incapacitated, and this power lasts until the authority is revoked or at your death. So for example, A signs a durable power of attorney making X his agent. A eats a bad jelly bean and goes into a coma. X would be able to pay bills, make business decisions, and make other decisions within the scope of X's authority until A is able to make these decisions again. However, this authority can be limited by the person granting it. So A can, in his durable power of attorney, list the authorities that he wants X to participate in. So two kinds of durable power of attorneys. Durable power of attorney 1, the agent gains the authority to make decisions for you when you become incapacitated, disabled, or incompetent. So it's only at those times. And the second type is a springing durable power of attorney. So here the person granting the authority specifies in exactly what cases their agents grants decision-making authority. So the person granting the authority can also specify if a doctor certification is necessary in order for your agent to gain decision-making authority. So going back to the previous example, but this time the durable power of attorney specifies that a doctor must certify that A has become incapacitated before X gains decision-making authority. If A goes into a coma when then a doctor would have to certify that A is in fact in a coma, and then at that time X can make any decisions for A. So the power of attorney can be revoked by any reason by the person granting the power, or it terminates at the person granting the power when they become capacitated again. The agent would also be required to be compensated for the actions unless the durable power of attorney specifically says the agent will not be compensated. And now we're switching gears and going into another topic, retirement in agriculture. So another rhetorical question. But how many of you plan to retire? This is something that you need to consider when planning your estate. So literature is full of active farmers' responses to survey questions on retirement plans. So Kirkpatrick in 2006 found 73% of respondents never planned to retire, only to semi-retire from farming. In Iowa, 27% of farm operators have identified a farm successor. So 73% have not, which is a little scary. It's also been found that U.S. farm net worth is over $1 million, but 76% of that is tied up in farm assets. So that's quite a large amount of assets, and without any sort of successor or estate plan in place, we don't know where those are going. So what does a typical farm family look like? So granddad is 92. No one really knows what he does in the operation. We have grandma. She's 87, and she manages the day-to-day operations. And then dad, who's next in line to inherit, is 65 and never had control of the day-to-day operations, but he's participated on the farm. And then the son, he's 31, will eventually inherit control from dad at some point. And there's a nice little picture to show what that might look like. So you might have laughed at the previous slide, but similar issues in agriculture exist across the United States. The grandparents' generation may not want to retire, and they still want to retain some control in the operation because maybe they started the business. They don't want to relinquish that control. The parents' generation may have only been farm labor, like dad in the previous slide, and never helped with management and marketing decisions. And the kids' generation may want to take over the farm and have necessary background to step in front of the parent. Maybe they've been to business school and they've tried to learn and be engaged. So the second generation parents may be missing critical management skills because of the first generation always did it, not wanting to relinquish the control. So for example, Cindy may not understand corn and soybean marketing because her dad Steve has always taken care of that. Cindy may not realize that she needs to hedge 1% of her crop each year. That's something that you only learn if you participate in that sort of management. So the first generation may not let second generation participate in these decisions in order to stay relevant to the operation. So they need to realize you bring a host of knowledge and skills learned over a lifetime that the second and third generations may not have at all because they weren't allowed to participate or didn't even know they existed. So what's the answer to this? If the goal is to continue to farm on past your generation, you need to let the successors participate in the day-to-day decisions. You need to let them understand the skills that will be necessary to continue on with the farming operation, and realize that your skills weren't learned overnight, so you can't relinquish control in 24 hours. You need to get them participating, immediately. Consider use of business organization structure. So I'll go into more of the business organization structures here in a minute, but this allows current generations to slowly give more and more control to successors while retaining some control. So first generation may retain some veto power over decisions of second generation, but maybe they're not participating in the day-to-day operations anymore. Business organizations may allow for first generation to continue to participate in profits of the farm, and this is where maybe a retirement plan can come in. So communication will be huge here. May realize that the second generation does not really want to have control of the operation once they start to communicate. So they may not be interested in making decisions, and maybe they already feel that they're too old. They want to retire and let the third generation take over. So communication will also help second and third generations understand how to effectively manage the operation and the decisions that they will be expected to make. So key is start to communicate early. So going on more in depth into some business organizations, a few include a partnership, which is an association of 2 or more individuals to jointly carry on a business. So each shares in the profits and losses of the partnership equally, and each individual has the authority to bind other partners. A limited partnership is similar to a partnership, but it allows for a separate class of partner who only provide capital and share in profits or losses, but they don't participate in any management decisions. A corporation, it's an entity formed under state law to act as a single person, separate from the individuals owning the business, and the right to exist indefinitely. A limited liability company is an entity formed under state law containing elements of both the partnership and a corporation. Each of these entities may have some place in achieving goals in estate planning by allowing for efficient continuation of the agriculture business from generation to generation. So multiple entities may be utilized depending on a person's goals. So for example, Bill runs a farming operation and owns multiple tracts of land. Bill has 2 children, Tom, who helps Bill in the operation, and Stacy, who lives and works off the farm. Bill may set up one business entity for the farming operation with the intent of passing ownership of this entity to Tom. Bill may set up another business entity that controls the farmland he owns and enter into long-term leases with the first entity. Bill may pass the second entity onto Stacy to allow her access to capital generated by the family farm. It's also another great way to pass on property and not have to worry about whose hands it goes into. So use of a business entity is one way to gift shares in the entity to family members. This is also another great tool. This allows parents to retain some control over the operation, reduce their future estate tax burden, and take full advantage of the yearly gift tax exemption. So the family could also set up a corporation with shares that can facilitate the transfer of ownership. Each parent can transfer at least $14,000 worth of shares every year without reporting on a gift tax return and without incurring any gift tax liability. This number will go up each year based on inflation, of course. In addition, the value of the interest gifted can be reduced by discounting since the recipient does not control the property and cannot easily sell this minority interest in the family farm. So a discount between 20 and 40% of the value of the gift property may be justified. All right, so we're going to take a time out and we're going to talk about one of the recent developments here in estate planning, and that is digital accounts. So many of us, I'm sure, keep more than we even realize on digital accounts online. if you sit down and make a list of them, you might have more than one email account, all your social media accounts, so Twitter, Facebook, Instagram, and then multiple bank accounts, credit card accounts, especially if you have a business or more than one business. Maybe there's a few different accounts on there. So the question that's come up is what happens to these accounts after we die? As you might have guessed, in Maryland, anti-hacking laws and privacy rights keep heirs and executors from gaining access to these accounts. So this can cause serious issues. For example, there could be a farm entity and the husband did not leave his wife the ID or password to the bank account that he pays the mortgages and leases and all of their bills on, and the bank won't grant her access because of the privacy right. So all of a sudden she's falling behind on her bills. So it's something that definitely needs to be taken care of, and states are now realizing the issue, and it's kind of scary. So what states are moving to do is grant family members and executors total control over a person's digital accounts after his or her death, the same way it grants those rights over physical documents. So Delaware and Virginia are two states that have jumped on board. So what can we do now until Maryland and other states fix the hole in the law? You can set your accounts up under business organizations. So whether that's a partnership or an LLC or something of the like, those accounts will pass to the successor, and you won't have to deal with those issues. It is important to note, however, that simply keeping a log of passwords and accounts will not solve this problem. The anti-hacking laws and privacy laws will still keep the executor from gaining access. So even if you incorporate those into your will, it's not going to cover all of that. Well, let's see here. That's all I have for today, a brief overview. Are there any questions I can answer now? Or also keep in mind, feel free to email me. This is my contact email, anewhall@umd.edu, and I'd be happy to follow up then as well.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel. Or to find a schedule of upcoming live webinars, visit our website.